Question 211. Owner Oscar provided broker Bruce with a listing to sell his home. Oscar informed Bruce that the neighborhood high school was rated among the 5 best in the city and asked for that fact to be included in the listing. Bruce didn't think the school's ranking was that good, checked the educational rankings himself and discovered that the school was actually rated dead last. Bruce showed the house to a family with 2 young children, the Flints, who inquired about the local elementary school, but not the high school. Should Bruce mention the high school's poor evaluation to the Flints and other prospective purchasers? A. No, it is the responsibility of buyers to inform themselves of pertinent information regarding the neighborhood. B. No, because it would probably impair Bruce's chances to close the sale. C. Yes, because the broker has a listing from a different owner, in a neighborhood with better schools, that he can try to sell to the purchasers. D. Yes, because it is a material fact. Correct answer is D. Yes, because it is a material fact. A material fact is any information that could significantly affect a buyer's decision to purchase a property. The quality and ranking of local schools are generally considered material facts, especially for families with children. Real estate brokers have a duty to disclose material facts to all parties involved in a transaction. Even if the buyers didn't specifically ask about the high school, the broker has a responsibility to disclose this information. The fact that the seller specifically asked for it to be included in the listing makes it even more important to disclose the correct information. Question 212. A broker accepts a prospective buyer's deposit and deposits it in his trust account. The broker also keeps his personal funds in the account to pay his office expenses. The broker is guilty of A. Conversion, B. Commingling, C. Accounting mistake, D. This is not considered wrong. Correct answer is B. Commingling. Conversion is the illegal use of another person's funds for one's own purposes. While commingling can lead to conversion, the specific act the question describes is commingling. Commingling refers to the act of mixing personal funds with client funds. Real estate trust accounts are specifically for holding client funds separate from the broker's own money. Keeping personal funds in the trust account, even for office expenses, violates this principle. Question 213. To be valid, a lease must include all of the following, except A. Description of the premises, B. Terms commencement and expiration dates, C. Tenant's credit history, D. Names of landlord and tenant, who have legal capacity to contract. Correct answer is C. Tenant's credit history. A lease is a contract, and like any contract, it must contain certain essential elements to be valid. These typically include: the property being leased must be clearly identified. The duration of the lease must be defined. The parties involved must be clearly identified and legally able to enter into a contract. Along with the lease being in writing, the parties' mutual agreement to the terms, and mention of the rent, as well. While a landlord may request and review a tenant's credit history as part of the screening process, it is not a legal requirement for the lease itself to be valid. The credit history is used to make a decision if a landlord wishes to rent to a tenant, and is not a part of the lease itself. Question 214. Which forms are required to be completed before an offer can be submitted? A. Credit application, B. Agency disclosure, C. Open listing, D. Title report. Correct answer is B. Agency disclosure. A credit application is part of the financing process, which typically occurs after an offer has been accepted. An open listing is a type of listing agreement between a seller and a broker. It's an agreement between the seller and the agent, not something required before submitting an offer. A title report is typically obtained during the escrow process, after an offer has been accepted. In most states, including California, real estate agents are legally required to disclose their agency relationship to all parties in a transaction. A form called Disclosure Regarding Real Estate Agency Relationship must be completed by a listing agent. This disclosure must be made before any offer is presented to ensure that all parties understand who the agent represents. Question 215. Which of these kinds of loans would probably require the lowest amount of settlement costs? A. VA. B. CalVet. C. Conforming. D. There are no differences in closing costs between these loans. Correct answer is B. CalVet. VA loans have some fee restrictions, but there are still certain required costs. Conforming loans, those that meet Fannie Mae and Freddie Mac guidelines, have standard closing costs, which can vary. The CalVet loan program, offered by the California Department of Veterans Affairs, is known for its relatively low closing costs. There are no escrow charges for CalVet loans. This is because the state itself acts as the lender, and they often streamline the process and reduce certain fees. Question 216. All of the following are encumbrances, except A. Lease. B. Homestead exemption. C. Mechanics lien. D. Easement. Correct answer is B. Homestead exemption. An encumbrance is a claim, lien, or liability held by someone other than the property owner that affects or limits the title to a property. It can be a right, interest, or restriction that diminishes the value or impairs the use of the property. A homestead exemption is a legal provision that protects a homeowner's equity in their primary residence from certain creditors. It is a protection for the owner, not a burden or claim held by someone else. A lease grants a tenant the right to occupy and use the property, limiting the owner's full control. A mechanic's lien is a claim against the property by a contractor or supplier for unpaid work or materials. An easement grants someone the right to use a portion of another person's property for a specific purpose. Question 217. If a lessee assigns their lease to another party, the lessee is A. is relieved of all responsibilities under the lease. B. could still be responsible just for rent payments. C. could still be responsible just for maintenance charges. D. could still be responsible for both rent payments and maintenance charges. Correct answer is D. could still be responsible for both rent payments and maintenance charges. In an assignment, the lessee transfers their entire remaining leasehold interest to a new tenant, the assignee. However, unless the landlord specifically releases the lessee from liability, the original lessee remains secondarily liable under the original lease agreement. In a sublease, the lessee transfers only a portion of their leasehold interest to a new tenant, the sublessee. The original lessee remains primarily liable to the landlord. Even after an assignment, the original lessee remains liable to the landlord if the new tenant defaults on the lease obligations, rent, maintenance, etc. This is because the original lease agreement creates a contractual relationship between the landlord and the original lessee. The landlord can pursue either the assignee or the original lessee if there is a breach of the contract. Therefore, the original lessee could still be responsible for both rent payments and maintenance charges if the assignee fails to fulfill their obligations. Only an assumption of the lease frees the lessee of agreed to obligations. Question 218. An agent, broker Brooks, fails to follow the instructions of his principal, owner Olivia. Brooks is A. liable to his principal for damages awarded by a court. B. subject to prosecution for a felony. C. subject to discipline by the real estate commissioner. D. both A and C. Correct answer is D. both A and C. An agent has a fiduciary duty to their principal, which includes following lawful instructions. If an agent fails to do so and causes financial harm to the principal can sue for damages. Real estate commissioners, or equivalent regulatory bodies, have the authority to discipline agents who violate real estate laws and regulations. Failing to follow a principal's instructions can be considered a breach of fiduciary duty and grounds for disciplinary action. Disciplinary action could include fines, suspension, or revocation of the agent's license. While failing to follow instructions is a breach of duty, it typically does not rise to the level of a felony unless it involves criminal intent, such as fraud or embezzlement. Question 219. Which of the following would be equivalent to an acre? A. A square with sides of 208 feet 9 inches, B. 43,560 square feet, C. 0.0015625 square miles, D. All of the above. Correct answer is D. All of the above. An acre is a unit of land measurement commonly used in the United States and the British imperial system. An acre is equal to 208.75 feet multiplied by 208.75 feet equals approximately 43,560 square feet. It's also equivalent to 4,840 square yards. In terms of square miles, it's 1/640th, equals 0.00152625, of a square mile. Historically, the acre was related to the amount of land that could be plowed by a yoke of oxen in a single day. This led to its traditional dimensions of 1 chain by 1 furlong, 66 feet by 660 feet. An acre as being roughly 90% of the size of an American football field, excluding the end zones. In essence, an acre is a standard way to measure land area, particularly in rural and agricultural settings. Question 220. A buyer of property in a land project may rescind his purchase and obtain a refund, even without a specific reason, within A. A week after purchase, B. 14 calendar days after purchase, C. 21 business days after purchase, D. There is no right of rescission for a land project. Correct answer is B. 14 calendar days after purchase. California law provides specific rescission rights for buyers of property in land projects. Specifically, buyers have 14 calendar days from the date of purchase to rescind the contract without giving a reason.